Good morning, Judge Stevens. I cannot hear you. Let's see here.
There we go.
Yep, there we go. I can hear you perfectly fine. It looks like we still have a few minutes before the start of the hearing. I can come back at
Great.
10 o'clock.
Okay, that's great.
Okay,
Thank you.
see you in a few minutes. Good morning, Judge Stevens. It looks
Good
like
morning.
we have representatives from both sides as well as the court reporter.
Excellent. Thank you.
Good morning, Your Honor.
Good morning. I'm looking forward to actually seeing you in a moment.
Few people say that.
Good morning, Your Honor.
Good morning. Okay, we are here for the case of Esposito versus the University of Michigan Board of Regents. Counsel, if you would be kind enough to state your appearances for the record.
Thank you, Your Honor. Good morning. My name is Thomas Kent. I'm here on behalf of the University of Michigan.
Good morning, Your Honor. James Acho on behalf of Ms. Esposito. My associate, John Wiley, will be arguing our position today.
Throughout this argument, we do have a court reporter who is currently not visible. We probably will never hear from her. However, if at any point in time she either loses the video feed or the audio feed, she will interrupt and will have the opportunity to straighten out whatever the problem is. If at any point in time any of us lose the video feed, we'll again stop and wait for an adjustment. With that, this is a motion for summary disposition filed by the University of Michigan Board of Regents. You may proceed.
Thank you, Your Honor. This is the university's motion, as you mentioned, for summary disposition. So there were, the basis of the motion is failure to give notice within 1 year as is required by the Court of Claims Act. I think that the parties agree that notice within 1 year is a requirement of the claim that's been filed. I think the response raises two legal issues. The first is the accrual date. When do we actually start to count that year? And the second is, what is the effect or the combined effect of the governor's executive orders 58 and 122 in terms of extending that 1 year period? So those are the two issues, legal issues, that were raised in the response. The university attempted to respond to those two issues in its reply brief. I want to spend less time, unless Your Honor wants me to spend more time, on the accrual issue. I think the body of case law and authority that exists, together with the representations made in the complaint itself, in terms of when the cause of action accrued, lead us to the conclusion that December 12th, 2019 is the date from which we should start counting that 1 year. So December 12th, 2019, 1 year, the notice or lawsuit should have been filed by December 12th of 2020. I'm happy to go back to the accrual issue and discuss the case law and the representations in the complaint, but she was provided notification of her position elimination on December 12th, 2019, knew about it at the time, never came back to work after that date. And it seems pretty clear that that's when we should start the 1 year running. The more difficult question, because it really is one of first impression that I don't know that any court or court of appeals has dealt with yet, is what is the effect of Judge Whitmer's executive order 58, which suspended
Governor?
Yes, I'm sorry, Governor Whitmer. Excuse me. What did I say?
You said judge.
Excuse me. What is the effect of the governor's order, the combined effect of 58 and 122, in terms of extending the period of limitations on which to file notices and actions? I mean, there's no doubt that the governor attempted to do that. And the plaintiff in this case is claiming that 102 days should be tacked on to that December 12th, 2020 deadline, which would get them into March of this year. The response
Counsel,
that
I understand.
Okay.
Scout's honor, I read this.
All right.
And I do understand that you have the position that at best her orders were efficacious through April 30th. They have the view that they had their full effect at 102 days.
That's outstanding, Your Honor. So I'm not going to go on. I'm not going to go on about that then, because the only thing that I would mention, and I reply, you've obviously, you know the arguments here. The only thing that I would like to mention before I turn it over is that any reliance or any argument that the plaintiff relied on these executive orders really shouldn't be accepted, because as of October 2020, everyone knew that the Supreme Court had ruled that the governor's order to declare the emergency only extended through April 30th. So even by October, the plaintiff still would have had 2 months, well, at least into December, a month and a half, to file timely, knowing that the order on which she relied to extend the limitations period was not effective beyond April 30th. So I just wanted to point out, to the extent that there's going to be a reliance argument, a good faith reliance argument, that it really isn't one that should be accepted by the court because of the timing here. Everyone knew in October that the governor's authority only extended till April 30th. So that executive order extending the period of limitations could not have reasonably extended the period 102 days. Thank you.
Thank you. And Mr. Wiley, the reason that we're here, of course, is that you filed a request for oral argument asserting that you were not able to file a SIR reply to their reply, and you wanted to address the issues in their reply brief.
Yes, Your Honor. So, good morning, Your Honor. The plaintiff agreement with the University of Michigan and Mr. Kent here that the 1 year statute of limitations applies. However, Mr. Kent is correct that we disagree with when the accrual date begins. The case law is fairly clear that the date of discharge is when the accrual date begins. And I'm holding in front of me the letter that Ms. Esposito received upon her RIF. Nowhere in the letter is there a discharge or termination statement. It simply says her position will be eliminated and the RIF period will last from April 1st, 2020 until April 1st, 2021.
And it's your assertion that during that period of time, she is still a university employee for many practical purposes, including being considered an internal hire and for outplacement into other portions of the university's hospital system.
Absolutely, and it's not just our position. That's official U of M policy that a person on RIF status retains their employee status. It comes with benefits such as being an internal hire, but it also comes with obligations and control maintained by the university. The big one here being that you cannot pull out money from your retirement and you can't access your retirement fund until the end of the RIF period. So U of M is clearly exerting some control over these employees while still formally classifying them as employees in their official RIF statement on their policy handbook and website. So until the end of the RIF period, the plaintiff and anyone on a RIF status is still considered an employee by the university. It's their understanding that they are not terminated yet, as example by the affidavit stated by Ms. Esposito. It was her understanding she was not terminated until the end of her RIF period. So it's our position that the accrual date can only begin once the termination actually is stated. And while not binding on the court, there is unpublished cases that indicate that a notice is not enough to start the accrual date. The actual action has to be taken. In this case, plaintiff was given notice of the elimination and the beginning of the RIF, while it doesn't take effect until the end of the RIF period, which would be April 1st, 2021.
Well, actually, there's another condition. If she declined to take a position within the university at 80% of her salary, she would be terminated as well.
Absolutely, Your Honor. In this case, Ms. Esposito ended up actually declaring retirement because she needed that money from her retirement account to make home repairs. So she ended up having to give up the RIF status and become an official retiree. However, that still does not indicate that she was officially terminated by the university on the date that Mr. Kent and the university is arguing. And then, Your Honor, going into the second point with regards to the governor and the Supreme Court, there hasn't been any notice or any statement by the Supreme Court that would nullify their tolling period. They used the governor's executive order and state of emergency as a timing for when their executive order or their administrative order would take effect, but they didn't rely on that for the basis of their administrative order. There has been no statement by the Supreme Court that would nullify, nor, as my understanding, there's any precedent for taking away that tolling period, which was reasonably relied upon by the plaintiff. Without Supreme Court precedent or Supreme Court statement nullifying their order, it's our understanding that it's still in effect. And I believe it would be most plaintiffs' understanding that it's still in effect without some statement by the Supreme Court or the government in general stating otherwise. So that being said, the 102 days would be tolled on the statute of limitation period, even if this court was to accept the university and the defendant's position, thus making the plaintiff's claim still timely. With that being said, Your Honor, it's plaintiff's position that this summary disposition motion should be denied and her claim should be allowed to go to the Court of Claims. Thank you.
Thank you. Anything finally, Mr. Kent?
Yes, Judge Stevens, the Supreme Court's administrative order by its terms was only to last during the time of the emergency declaration. So the Supreme Court's administrative order is tied to the governor's executive authority to issue emergency orders, which ended on April 30th. On the accrual date, Your Honor, the problem I'm having here is there is not one case, federal or state, that says that the adverse employment action is tied to the termination date. Not one. And even the case that the plaintiff cites here, Salisbury versus McLeod Steel, that court said the fact that a plaintiff may have subsequently received vacation or severance pay from defendant is irrelevant. The United States Supreme Court in the Delaware State College case says the only alleged discrimination occurred, in Delaware State College, held that the plaintiff's cause of action accrues when she received notice of termination, not when employment actually ceases. There is authority.
So counsel,
Yeah.
here's what I want to understand. It's your contention that under these circumstances, she should have sued for constructive termination or actual termination prior to her date of termination.
That's right.
When in point of fact, she was supposed to be eligible for outplacement. I'm just calling it that, elsewhere in the university during that entire year.
No, she's eligible for RIF status after. Okay, so let me back up a second. The policy at the University of Michigan is someone with a certain amount of seniority gets 90 days notice. Okay, and that was her. What we do sometimes is say, your last day of work is today. We're going to pay you for 3 months, but you're not coming to work. You're gone. You're not doing your job. But because you have a 3-month notice period, we have to continue paying you for those 3 months. She was gone. She never came back after December 12th. She knew she was eliminated, never came back to work, and was only being paid. And then she has from April to have priority hiring status if new jobs come up. So, she knew, she could have filed on December 13th a cause of action alleging wrongful termination of the Civil Rights Act because she knew she was not coming back. And in fact, we told her, we don't need you in the office. And so this is absolutely not a situation, and no case has ever held that the adverse employment action is tied to the actual termination date. It's tied to when the person receives notice and can maintain a cause of action from that date.
Okay. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, the case will be submitted and you'll receive an order probably within 10 days.
Thank you.
Your Honor,
Thank you very
Thank
much.
you.
Have a
Have
good
a great
weekend.
weekend.
Thank
You
you.
too.
Tom, happy Father's Day to you.
Thank you. You too, guys.
Thank you. Be well, Judge.